Court is resumed. Please be seated.
As we get to the close of my submissions, approximately a quarter century after I started, I'm going to move to NCRRs. And I hope to, that I maybe got an hour and a half left, maybe. NCRR's spectrum. Oh, sorry, before I do that, point of correction, Ms. Lewis pointed out that I had given you the wrong figure when we were comparing Stiglitz and Hutchings resource rent revenues as opposed to Smart and Bodeways. I said it was 3.586. That was, of course, their net. Their gross was 3.951. The point is, you still wouldn't compare them. I just gave the wrong number to the monitor.
Okay.
Right, so on page 14 of our compendium II, you'll find the correct gross nominal resource rents from which you have to deduct proper expenses. And those proper expenses are not 2.897 billion, they're 0.365 billion.
So not 2.89, but
0.365 billion.
thank you.
Right, so I apologize for the wrong number. Turning to spectrum. Yes? I'm just waiting for the court.
No, go ahead.
Yeah. Canada didn't address our main point. Spectrum licenses, by definition in the Radio Communications Act, are expressly tied and limited to a particular geographic area. Other than that one point, we saw nothing in their argument that requires us to reply, and we rely on our written and oral submissions as before. There were complaints made about Mr. Hutchings' approach. Ontario, yes.
I'm just looking at the transcript.
Yeah.
Are or are not expressly tied and limited to a particular geographic area?
Are expressly tied.
Right. Thank you.
Thank you. If yes, are expressly tied and limited to a particular geographic area. Turning then to complaints about Mr. Hutchings' approach, Ontario, about NCRRs generally, Ontario spent a fair bit of time going over what we say, well, sorry, what they say were errors in Mr. Hutchings' approach. We stand by our written and oral submissions that his approach should be preferred. Counsel for Ontario, consistent with Bodway and Smart's tenor and consistent with what Mr. Smart said, alleged that Hutchings invented numbers. That's just not fair. I would say that Mr. Hutchings brought his considerable expertise to bear, and where the data was unavailable or unreliable, he developed proxies or interpolations that in his opinion were reasonable. Moreover, he was not effectively cross-examined on his findings, opinions, or conclusions.
Let me just count up for a moment, please.
Yeah.
Go ahead. Thank you.
When it comes to expenses and what expenses to count, what is missing from Ontario's argument is any relation of expenses that meet the test of causation, remoteness, and foreseeability in respect of expenses. They say to the plaintiff, where have you proven this? Where have you proven that? Where's the causal connection? It's too remote, it's not foreseeable. So they say that about our case, but in putting to the court expenses, they simply ignore that requirement. They don't connect their expenses to expenses that are in any way related to, cause, connected to, foreseeable with expenses that support relevant resource revenues. I would now turn to briefly the post-1945 expenses. In their argument, Ontario alleged in their oral argument that Mr. Hutchins did not include expenses after 1945. I think my friend, this was a slip of the tongue, so to speak. I think my friend meant to say that he did not include the level of expenses that Ontario argues is appropriate. Of course, he does include expenses by virtue of the fact of he's taking a ratio of expenses. Secondly, Ontario argued that Mr. Hutchins did not look at the data post-1945. Again, this is not fair. I believe his evidence was he did look at the data and he found the data wanting. Ontario counsel in argument orally referenced evidence from Professor Smart providing 3 reasons why NCRRs became negative after the 1960s. Now, the court may recall that these 3 reasons were introduced by Professor Smart during his direct evidence on slide 18 of Exhibit 70. And I've reproduced that at our compendium, QQ, tab 9. So the court might recall that objection was taken in court, and Ontario took the position that there was nothing new in what Professor Smart was testifying to. If you look at slide 18 of 161, which is at tab 9 of the compendium, you will see that there's a reference to nominal values report, figure 1, and section X. And what Ontario Council didn't tell you yesterday was one of the important things, and perhaps this is the most important point. Ontario ignored the caveat that Professor Smart himself gave to this evidence about reasons for negative NCRRs right on the slide itself. That although there's 3 reasons, these reasons, the decrease may also reflect policy decisions on level of support to the resource sector. And then he says, issue is of not part of our assignment, and we do not speculate on this. So they didn't look to see how much of the increase in expense was related to their alleged assertion of depletion of resource stocks, decline in real prices, and forest regeneration expenses rising. His opinions on slide 18 are really nothing more than untested hypothesis.
Can I just ask?
Yeah.
That caveat, as you say, is on slide 18. And but it doesn't specifically say how it fits into one of those 3 or around those 3.
Well, his evidence was in accordance with this.
Sorry, what should we call those 3 tabs above? Reasons why? Reasons that explain?
Reasons why Professor Smart put forward why their NCRR losses became negative in the 60s. That's what he says. We will show that NCRRs and RST became negative beginning in the 60s, and then he gives 3 reasons. But then he says, yeah, but the fact that they became negative may also reflect policy decision on level of support to the resource sector. That's not connected to relevant resource revenues. And to say that they didn't examine the question is to say to the court, well, in effect, these may be reasons, but we didn't examine it. We don't know how much is attributable to the policy decisions as opposed to these other elements. And we're going to get to a demonstration on the very next page about how this plays out, because you'll see on slide 18, it says nominal values report figure 1 and section 10, which I've reproduced in its entirety on the next page of the compendium. Now,
sorry, is this page, oh, this is just tab 9, not numbered? Oh,
tab, it's on the bottom of the, sorry, it's on the bottom of the page. The computer generated a number right on top of the
I see it.
number of the report. So paragraph 127 and following. And there's a couple of things that you should observe. Nowhere in figure 1 or in section X will you find the opinion set forth in slide 18. It's not there. Now, part X, paragraph 127 and following, it's about 400 words long, and contains not one footnote and has not one citation.
Where's figure 1?
Figure 1 is in the main body of the report. I didn't reproduce it.
Okay.
It's unrelated to this.
Okay.
I perhaps
Oh,
should.
nowhere in. What's significant is in part X or Roman numeral 10.
In Roman numeral 10, I'm saying that these principles are not set forth. I think the argument could be made that, well, you know, in some respects, it's almost touched upon, and maybe you could infer that that's what they are, or that's what he was maybe getting at. And I think Ontario would say, well, you know, an expert isn't limited to the strict wording of their report. And, you know, these are areas that are still within his area expertise that he could speak to. Okay, that's their position, but it's not in his report. And what he did say, the first point is what he did say is equivocal, right? It's equivocal because he concedes that the reason for the negative result may be a result of policy decisions on the level of support to the resource sector, which, as I said, has nothing to do with relevant resource revenues. And then I wanted to take you to paragraph 127 and following, and I said, there's no footnotes, there's no citations. Now, neither Professor Bodway nor Professor Smart claimed to be resource analysts. They're economists. There's no evidence of forest regeneration in RST. This heading is province-wide net revenues. And when you actually look at what they say, they're talking about RHT. So I've highlighted on the page, mining revenues peaked in the late 1970s, has been declining ever since, which mostly reflects a decline in real revenues from mining profit tax. While taxpayer confidentiality concerns prevent us from examining revenues from individual companies, it is tempting to infer that this reflects, in large part, the decline of nickel production in the Sudbury area. Okay, well, to the extent that it's meaningful for an RHT case that isn't before you, that's fine, but this isn't about RST. Now, it's true that the RHT was exploited to a greater degree than RST. More revenues were generated from that territory over the last 173 years. So perhaps this is what Bodway and Smart are referring to. We have no way of knowing that Bodway and Smart's opinions about depletion of stocks, real resource prices, and rise in forest regeneration have anything to do with the RST area in specific. Now, of course, Professors Stiglitz and Hutchings could not directly respond to this slide 18 in their reports or in their direct examinations because it hadn't yet existed. So it was a new point. And there was no need for Stiglitz and Hutchings to deal with part 10 in their report or in their testimony in direct, because it appears to be dealing with RHT.
When did slide 18 come in the reply?
No, slide 18 came up when Mr. Professor Smart took the stand and presented his slide deck. And I specifically objected to slide 18, saying I thought that this was not in his report. Now, what is surprising about this so-called evidence and what weight you give to it will, I think, depend on how you consider this. It's surprising to me that if those assertions on slide 18 were so critical for Ontario's case, why weren't they put to Stiglitz and Hutchings? Stiglitz and Hutchings were on the stand. They could have explained it, but Ontario didn't put it to them. Of course, once Stiglitz and Hutchings left the stand, and considering the equivocal nature and content of slide 18, and the fact that Professor Smart failed to demonstrate that the three factors he cited were causally connected to increased expenses in the RST, question is, should the plaintiffs have started cross-examining him on such equivocal, weak evidence? I didn't. I didn't see any need to. Slide 18 and the evidence about it is a good example of evidence that's simply not helpful to the court. I want to turn now to the proper expense ratio. Mr. Hutchings opined that 1898 to 1945 was a meaningful average to take, and he was not shaken on that point during cross-examination. I have a couple comments to make with respect to Ontario's chart at tab 16 of their closing submission compendium, volume 2. You might recall those were tables prepared by Ontario's counsel that were put to Mr. Hutchings during cross-examination. And in oral argument the other day, it was last week, Ontario counsel pointed to the possibility of using other expense ratios. And they said, why not use 1 year, 1945? Well, using 1 year doesn't indicate any trend. Another option Ontario had is, well, why not use 1940 to 1945? Well, a 5-year period is not necessarily representative of a trend, especially since 1940 to 1945 are the war years. And as for the third option, Hutchins explained why using a ratio going back to 1850 was simply not reliable and not appropriate. Next, I'll wait for you to catch up.
Thank you. Thank you.
Next, Ontario argues that using an expense ratio ignores the without incurring loss factor. And this, at Ontario's Compendium, Volume 2, page 51, Professor Smart's slide 17, Exhibit 70 was reproduced. And you might recall that the way that it was presented by Professor Stiglitz, he said there must be a net positive result. And the position that Mr. Hutchins took, no, not that there must be a net positive result, but there could be negative results. And so
Who said there must be a net positive result?
Smart said Smart accused Hutchins of taking the position that there must always be positive results.
Was Professor Smart saying that using Hutchins' approach, there must always be a net positive result?
In every single year. Yes, that's what he alleged. And I want to take you to tab 10 of our compendium, which is the slide that of Mr. Hutchins that Mr. Smart misquotes, right? So Mr. Smart, Professor Smart, excuse me, forgets to mention or concede, he forgets to admit that Mr. Hutchins says negative or zero results are possible. And so Ontario's setup to their argument the other day was that Mr. Hutchins doesn't allow for any negatives. Well, he's wrong.
Wasn't he cross-examined on this point? Maybe I'm wrong. You would have found.
Well, you know what? I can't remember. I believe he was. I believe Mr. Professor Smart was, but I don't have it in my mind.
No problem.
Yeah. Perhaps it would have been easier just to go to that cross-examination. You're right. But Ontario next sought to use a casino example to show that an average net positive amount means that you never consider some years might be negative. And Ontario was bold enough to say that the plaintiffs do not understand math, I suppose. And then Ontario took you through what I believe, this is my understanding, was an erroneous explanation of math and the law of averages. And to drive home the point about Ontario's casino example, I want to give you a simple 2-year casino example that I think will straighten things out. Here we are, year 1. Guy goes to a casino, wins $100. He's very happy. Doesn't go back to the casino that year. He's got $100 in his pocket. He's happy. He's got $100 profit. Year 2, he goes back to the casino. He loses $68.10 because he was playing the penny machines. He's very sad. He goes home after the end of year 2, looks at his spouse, her spouse, and says, lost money. Spouse says, well, don't be so sad. You're still up $31.90. That's your average. So over the 2-year period, no one would suggest that our casino gambler did not lose money in year 2. He most surely did. Well, but on average, he's ahead of the house, which raises another interesting analogy. The phrase, the house always wins. Now, the reason why the house always wins because of the percentages. And if the house didn't always win, they wouldn't be in business. So casinos have to set their slot machines and their table games to return to them, on average, a positive surplus, even if some gamblers win and some gamblers lose. And I think that was the point that the court was making the other day. If they don't set their rates to get a positive surplus, they should not be opening their doors. So the casino example raises another important analogy for this case. The purpose of the treaty is to share in the future potential and future opportunities in a way that would provide for both Crown and Anishinaabe. And the Anishinaabe are not supposed to be passive casino patrons doomed to lose with certainty, with Ontario alone being the house. A better and more proper analogy is the Anishinaabe are part of the house, sharing in the future benefits that are generated by the casino joint venture. That is a more appropriate analogy as to what the treaty should be. With that, I want to turn to the music festival analogy. Now, the court may recall there was a music festival analogy that Council for Ontario used, and I'm going to suggest to you that that analogy actually supports the plaintiff's case, and Ontario made a significant error in presenting that proposition to the court about the music festival. The biggest problem I think Ontario made is that giving me the opportunity to talk about music would cause anyone who was present in phases 1 and 2 to know where this is going to lead. And there's only a couple of us in this room who were there at phase 1 and 2. But look, I was working late on my submissions the other night. I was, what they say, burning the midnight oil. And my mind drifted to a comment made by one of the court staff in Sudbury a few months ago. One of the court staff came up to me and said, and I'm not going to say who it is, you know, wrestlers and baseball players have walk-up songs. What would your walk-up song be, Mr. Schachter? Now, I thought to myself, walk-up songs? Like what? It might be like... So Rocky had a walk-up song. Rocky had a montage, but that's another story. So Rocky has a walk-up song. And I thought to myself, well, you know what? Lawyers are often seen as gladiators of the gab, warriors of the word, pugilists of the page. So I thought, is there a walk-up song for me? I thought about it. You know, I thought maybe, well, how about someone mentioned Thunderstruck? I thought, no, that's way too egotistical, you know, just didn't ring true. I could not think of a song, a walk-up song for myself, but I did think of a walk-up song for the Crowns. It came to mind. Why did it come to mind? There I was burning the midnight oil. And I thought to myself, how about a song by Midnight Oil? Now, no, not yet. Midnight Oil is an Australian band known for their songs that invoke the listener to act in a socially responsible way. They have that history. Now, for those of you youngsters, they're a band really, I think, from the 80s. But Midnight Oil, I'm going to use Midnight Oil because they had a concert at Massey Hall last year. Still rocking on. June 13th, 2022, Massey Hall. I missed the concert, but I have no doubt that they sang their #1 hit song, which is #1 in Canada, probably for a reason, Beds Are Burning, a song whose lyrics, perhaps only slightly changed by me, made me think of a perfect walk-up song for the Crowns.
Could we please do proper reply, Your Honor? Please. Please. This is not amusing.
After 25 years or so of working on this case, I thought that a little levity might be just okay. If it is inappropriate,
It appears not to be falling well.
okay. So I will just read then, instead of performing, I will read the words that I think are true. And that is where Midnight Oil say, the time has come to say fair's fair, to pay the rent, to pay our share. That's it.
Thank you.
And I guess I would only add that I note that the author of that song didn't say it had to be a fair share, just a share that is fair. But the reason why I went to the music festival was because in deciding on the ticket prices that they would have to charge, the concert promoters would ensure that all foreseeable costs are covered. They would act with common sense. They would estimate the cost of holding the concert and would set the price of tickets to ensure that there was a reasonable prospect of profit, or else they wouldn't bother with the concert. In deciding on the expenses that they would take into account, they would look at such things as the cost of the hall rental, the cost of paying the band to play. But there are other expenses that they would not reasonably factor into their consideration of relevant expenses. And those would be expenses that are unrelated to the holding of the Midnight Oil concert. They would not factor in such things as a portion of the cost of building Massey Hall, which was not built for that concert. They would not factor in the cost of building hotels that concert goers might use that were built for purposes other than the concert. The concert promoter would not start factoring in the cost of building the subway and the GO train rail construction that would bring the concert goers to the venue, nor would they factor in the cost of construction of various parking lots that were already there and built for other purposes. My point is, each of these infrastructure costs undoubtedly has some benefit to the concert promoter, but no reasonable person, no reasonable accountant, or no reasonable economist would take such unrelated costs into account in determining whether the concert promoter made any money in holding the concert. And yet, this is precisely what Ontario has done in their submissions. We ask you to reject their approach. Turning to the mathematical certainty of 77 billion. Again, reminding you that Canada said in their submission that Well, because they're, each year has a particular interest rate and a particular bring forward rate, you can't know that the 77 billion is accurate. Well, yes, you can, and that's because of math. The $77 billion figure on page 18 of Exhibit II, it doesn't have to be in evidence. It's a mathematical calculation of certainty. You get to 77 billion mathematically because the 126.3 billion has been done mathematically, and that is in evidence. And the 56.89 billion also is in evidence and was calculated mathematically. And all the difference between 56.89 and 77 billion is taking an extra 30% in each and every year and multiplying that extra 30% by the very same factors in each and every year. It must, as a matter of mathematical certainty, simply be 30% greater. It's apples and apples. And you can just think about it if you earned $1 in 1926, and now we're saying you would have earned $1.30 in 1926. The bring forward formula for $1 is the same as the bring forward formula for $1.30 in 1926, and in 1926, the same interest rate would apply throughout the whole period up to 2019 on whether it's $1 or $1.30. At the end of the day, you just end up with 30% more. What would likely have happened with the annuity monies? We say they would have gone to the bands because the treaty says that the annuity money must be paid out. That is a treaty promise. Of the amount that must be paid out, a maximum of $4 per capita can go to individuals unless the Crown exercises its graciousness to increase the $4 per capita. There is no evidence that the Crown sought to exercise its graciousness to increase the amount to individuals beyond $4. So we know as a matter of certainty that every penny over and above the augmentation above $4 must have gone or would have gone with certainty to the collective. That is the only place it could have gone unless the Crown exercised its graciousness to increase the amount to individuals, which it did not. Ontario, maybe Canada and Ontario, I forget which at this point. The argument made was that, well, when the money got to them, they could go and buy bonds. Well, but think about that. How would someone go and buy bonds? If they could go and buy bonds, they would go to someone who's with knowledge about how to invest. And that person could say, don't buy bonds, buy stocks. The very same person they would go to invest in bonds would be the person that they could go to buy equity. Canada I believe, sought to rely or seeks to rely on the 2009 Ermineskin case. And arguing that even a fiduciary duty would not require investment outside the band trust accounts. But Ermineskin was clear. The reason for that was that the fiduciary was statutorily limited to the band trust accounts by express statutory provisions. And that can be found at Ermineskin paragraph 136.
Sorry, what does,
You're looking for the principle or the citation?
I'm just trying to make sure I have what you said. The reason for that,
I'll try again.
the fiduciary duty was because statutorily,
No, the fiduciary duty was limited to investing in the band trust account rates because statutorily, that's all the fiduciary was permitted to do. And the Supreme Court of Canada at paragraph 136 explained that a fiduciary can be limited by statutory restrictions. And of course, that would have been a problem in this case if the Crowns had alleged and if they could have proven that the annuity monies were Indian monies, because then there would be certain restrictions up to 1951 and the like. But they didn't make that case. They didn't argue that case. We say that they are not Indian monies, and everyone seems to agree that the money would have gone to the band collective, or would have had to have gone to the band collective in this case, I say, and they would have done with it what they would have done with it, and would not have been restricted to the band trust accounts. Indeed, the Crown say you couldn't have put it in the band trust accounts. You had to put it outside the band trust accounts. Now, on September 20th, when talking about real rates of return over time in the real world, where one could secure a real rate of return at 6% or more, 6% without persistent inflation in 1850s and equity rates of return of averaging over 7.2%, more in the range of 11%. Canada argues there's no evidence that the RST wouldn't have been satisfied with a real rate of return of 1.44%. Respectfully, common sense tells you otherwise. In any event, this idea that the Anishinaabe would have been satisfied with 1.44% is a hypothetical world that Canada is setting up that they would have the onus to prove. I wanted to turn thank you. I wanted to turn to the issue of depreciation. You might recall that Stiglitz and Hutchings' evidence was that depreciation is baked into the returns they've already done, and there was a dispute between them. And I just want to remind the court that when Canada talked about Booth and Kersner having how important it is to take off depreciation, Stiglitz and Hutchings explained in their opinions that that was in effect double counting. And if you look at tab 15 of our compendium, page 71, you will find a document that was put to was it Booth or Kersner? I believe we put this to Professor Kersner. But I want to focus on the bottom chart because it identifies where in Stiglitz and Hutchins' report they identify the problem with depreciation. Because if you start at I'm just focusing on the business.
I'm looking at tab 15. Can you remind me where these annotations come from?
The annotations were handwritten by Miss Lewis as we presented them to the witness.
Thank you.
And there's a chart at the bottom, and the reason for the chart is not to suggest that there was a take up by Booth and Kersner on this. I don't think there was, but I believe that it's a good handy reference to where Stiglitz and Hutchins identified the problem and comparing where the data on the various rates come from. And the point to remember, and I'm using this chart at the bottom to help the court remember that Stiglitz and Hutchins' evidence was that, and we're just going to take a look at business, for example, if you have a Booth and Kersner report business rate of return of 8.2%, and you have a depreciation rate of 5%, that leaves you with an effective rate of return after depreciation of 2.8%. And that offended the Stiglitz and Hutchins smell test, where they said, well, why would anyone ever invest in business if you could take a risk-free rate of return of 5% instead of getting 2.8%? It makes no sense. And so Stiglitz and Hutchins sought to explain that Booth and Kersner had in effect double counted depreciation. Both crowns argue that realistically, Canada would have prevented RST and Anishinaabe from investing in the market and would have forced them to use banned trust rates. Well, in another breath, they then argue that all that was available to them was long-term bonds. Well, this is an inconsistent statement. The crowns, of course, take the position that BTA rates were not available. I would add, if it's true that the Crown would be investing the band's money, they would then once again be fiduciaries with the fiduciary responsibility to invest those monies. If Canada would have had a fiduciary obligation to invest in money and there was no legislation requiring them to only invest in the band trust accounts rates, it is speculation and not evidence to suppose that Canada would have insisted on putting that money into the band trust accounts each and every year for 173 years, as opposed to a more appropriate investment type, given the huge amounts of money we're talking about. As for Ontario, if Ontario is directly responsible, there is no legislation at all concerning what investments Ontario would have been constrained by. The money in if either Crown wanted to posit that the money would have made its way only into the band trust account rates or only into bond rates, surely that is a hypothetical world that they had a duty to bring some evidence. My submission is they did not meet that test. I wonder then if I could turn to the issue of pension rates of return.
Just let me catch up for a moment, please.
Yeah.
When you say if Ontario was directly responsible, there's no legislation that would have constrained them, or do you say that would have authorized them to keep the money or constrain them on how they invested?
It would be constraining their fiduciary responsibility to invest what would have been our client's property. Remember, under the theory where the crowns take control of our money, they do so as a fiduciary. There is no other way, unless, of course, it's theft, right? Either they get the money and take charge as a fiduciary, or they leave the money with the plaintiffs. If Ontario has the responsibility to pay and it's not Canada, the money comes from Ontario's coffers. And if Ontario says, we're going to hold this for you, we don't trust you to spend it, we're worried that if we just give it to you, we're going to spend it, Ontario would have the responsibility of a fiduciary. Now, of course, neither crown wants the responsibility of fiduciary duty, so they say the money would have been paid out. But then they say, okay, we would have paid out the money, but then you couldn't invest it. You wouldn't have hired anyone special to help you. You wouldn't have invested it in various markets. You would have chosen to invest it in bonds. Well, the evidence doesn't support that that's what would have happened.
Thank you. Go ahead.
Turning to pension rates of return.
Yes. Thank you.
This court's determination on a proper bring forward rate should not depend on what ultimately is an equivocal printout of some pension plan returns in one document. It is true, there was no cross-examination on this. Mr. Marcello fairly made the point that there is no breakdown of the riskiness of the bonds. The bonds can be corporate bonds, they can be municipal bonds, they can be Canada savings bonds. There's no identification of the nature of the risk, nor is there any discussion in the reports, Bodway and Smart's reports, about what kind of pension plan restrictions there may have been, or what each pension plan examined, what their requirements were on a yearly basis. Recall the evidence, I think it was of Professor Booth, I'm just going from memory, saying that one of the important factors in deciding how to invest and how much you put in equities is how much liquidity you need in any one given year. So part of the problem is we don't know from these pension plans, from looking at the document, this one document that my friends rely on, exactly how much cash was needed and needed to remain liquid. We even don't know how liquid many of those bonds are. We can recall that included in, it's not just 11% in stocks and the balance in bonds. We don't know how many of the bonds are risky, but there was also mortgages, foreign investments, shares, and other assets.
Could you remind me, please, what exhibit number, page number that printout is?
It would have been in Ontario's volume 3 of 4, I believe. And I'll look to my friends if they can pull it up before me, that's great. If not, I'll find it shortly.
Thank you.
I believe it would be 41.
Page 41
Oh, no, tab 42.
of volume 3.
Tab 42 of volume 3 of 00,
Yes.
exhibit 00.
Thank you.
And if you actually could do the math, it's not 11% alone in unsecure. You can't tell that it's only 11% in risky assets. There might be substantially more. And in its argument, Ontario just looked at 1 year. And of course, as you go, even in 2 or 3 year increments, the percentages change. So the message here is don't decide this case on that one document. A little bit more on bring forward rates. Common sense and the evidence before you tells you that with the kind of money payable in this case, if you accept Mr. Hutchings' calculations on NCRRs, beginning in around the 60s and 1860s and 1870s, that would have given the Anishinaabe a generation to develop the expertise and knowledge that could be required of them. And the evidence on this was from 2 sources. There was Dr. Dribbin, and I've got that at tab 11 of my plaintiff's reply, closing submission compendium, where at page 49 of the compendium, transcript page 1866, Dr. Dribbin says, now how long would it take for the Anishinaabe to become equal partners with the Crown and administer the annuities themselves, the augmentation clause themselves? It would take, I think, about a generation. And I say this based on my experience. He then goes on to explain about his involvement with Anishinaabe, an Anishinaabe physician and family advisor. And over on the next page, he says, but like I said, if hypothetically you have a proper support system, it would take about a generation. And we know that from the historical record of, as I say, Anishinaabe becoming fur trader and clerics. And from contemporary situations, we see Anishinaabe behaving in ways that are just like everybody else. You see, Mr. Schachter, there's no difference between Anishinaabe and other group of people. They're human beings, and they have the same equal potential as all human beings. And speaking of other human beings, we have Professor Booth on the very next page, compendium page. Oh, sorry, Professor Kersner. Excuse me. Professor Kersner at page 51 of the compendium, transcript page 3605, line 9, question. So a person or a First Nation that wanted to make sure that the monies that they received would last and benefit 7 generations, that's not enough knowledge? Answer, no. They'd have to understand risk. And to understand risk, you have to have good investment knowledge. You have to understand that prices rise and fall, and that you could have a 30% decline in the value of your investments. You'd have to understand and know that you could withstand that, and that you wouldn't panic or do something foolish. That whole behavioral side is also critical. Question: how long did it take you to learn that principle? Where did you learn that? Answer: interesting. Well, I started studying and applying investment finance around 1968, 69. I read some very important books. I opened up accounts. It took me quite a long time to really understand that. Question: 3 years? 5 years? Answer: I think it probably took me 5 to 10 years to really solidify what the factors are for making good investment decisions and what represents suitability. So this evidence tells you that within a generation, the Anishinaabe could have been in a position to invest for themselves with knowledge of risk. And I might add, even without the knowledge of risk, even without the massive amounts of money that should have been paid to them in accordance with Stiglitz and Hutchins calculations, the facts, as the evidence revealed, were that the spending patterns suggested massive savings, not massive spending. And just because the court had at some time in the last couple of weeks raised the issue of where does the 93% versus the 47% come from. If you go to tab 13 of our compendium, you will see the slide that we put to Professor Kersner. And this is where we put it to him that they had not calculated the expenses, not calculated the expenses taken from both capital and revenue accounts. And you might recall that in all the other work they've done for all the other cases, it was always capital and revenue. And today, or sorry, this week, I think Ontario, maybe Canada, excuse me, Canada says to you, but there's no spending from capital. Well, there might not have been spending from capital, and that's because it was saved from capital. The question is, can you spend money from capital? Well, yes, of course you can. That's why Booth and Kersner would use capital and revenue accounts to look at spending patterns, because both of them matter. And if you look at tab 14, lest there be any doubt about the ability to spend from what is called capital, we've got the excerpts of all the Indian Acts. And the first reference to the capital accounts that we could find in the Indian Act is 1897, although if you, sorry? Sorry, if I misspoke, the first reference in the Indian Act at page 64 of our compendium is reference to paragraph, an amendment from 1894. Now,
Tab 14.
yes, tab 14. Now, if you look at Eric Angel's report, he refers to the existence of capital accounts well before that time. But I think if you read through his report, I think you'll gather that those may have been administrative accounts with no specific statutory identification of whether you could spend from them or not. And where you, in 1894 is when you start seeing some reference to spending. At least, I'm not sure whether it's in 1886 with a slight amendment in 1894, but around that time, 1886 to 1894, the governor and council may, with the consent of a band, authorize and direct the expenditure of any capital monies. And what can it be used for? Purchase of land, addition to reserve, purchase of cattle, construction of permanent improvements, any such works in connection that will be of permanent value to the band. Go through to the next page is the 1906 version. You have similar verbiage. Looks to be amended somewhat in 1924. I don't need to read all of these, I don't think, do I? Then in 1906, you have, and this is at page 66, you have the Crown being able to unilaterally spend capital money. If the band refuses to consent to the expenditure, as the Superintendent General may consider advisable, and if the Superintendent General thinks that it's detrimental to the progress or welfare of the band, the government and council may, without the consent of the band, authorize and direct expenditures. Another major milestone was the 1927 version of the Act, and you'll see at paragraph 93 on page 67 of the compendium, capital spending, and again at the bottom of the page on section 2, unilateral Crown, the ability of the unilateral Crown to spend capital monies. And then in 1951, you have the formal definition or the formal use of the word Indian monies. This is at tab 68. Sorry, tab 14, page 68 of the compendium. You have the 1951 Management of Indian Monies sections, and at paragraph 64 of that 1951 Act, you have, with the consent of the Council of the Band, the Minister may authorize and direct expenditures of capital monies. And now here we have capital can now be used for per capita payouts up to 50%. The 1970 version on the next page, page 69, paragraph 64, continues with the same idea. And I didn't include in the more recent versions, but it's all to the same effect. The point is that capital accounts were used in the past in their analysis by Booth and Kersner because that is a place from where spending could be made. And the fact that it wasn't made is just evidence of savings as opposed to evidence of spending. So to ignore it is unfair, which is why the proper number is 93% savings. And that's 93% even on the limited monies that the band's got. And we know from the evidence that spending patterns actually change when people get more money. I think I have about 50 to 20 minutes more. And that would conclude my submissions. So it is kind of time for a break, or we could push through. What is the court's preference?
Break. We'll take a break.
All right.
This court is down for 15 minutes.
Order, all rise.
Court is resumed. Please be seated.
Continuing on with our discussion about bring forward rates, the court might recall that during the trial, there was an objection to the accounts of the Six Nations going into evidence. And during argument, Ontario argued that, well, I can't remember if it went in equivocally or with reservations. The accounts say what they say, and we've got at tab 12, we've got account number 10, which was exhibit 75. And just to be clear, the information in exhibit 75 is actually found together with all other years that I was actually trying to get into evidence. It was already in evidence from phase one. It's part of the Bagot Commission report. So it's all there. I think I maybe intimated somewhere along the trial that I believe that it was in the Bagot Commission report anyways. Here it is. It's appendix number 89. It's at page 56 of the compendium, tab 12. It's a fair point to say that there wasn't expert evidence on it, but they are entries that tell you something about where investments were being made. I would simply ask you to turn to page 58 of the compendium for a moment and to take a look at what the Bagot Commission report identifies. So the Bagot Commission, first of all, the Bagot Commission report was stage one trial exhibit 1-0499. And we're looking at page 58 of the compendium, and under the CR for credit, these are the monies coming into the Six Nations of Upper Canada accounts. And we have the very first one on July 15, 1836, being interest due to the Six Nations from an individual by the name of Markland. But if you go down, you've got by proceed to December 2nd, 1836, by proceeds of a bill of exchange on London for £386 sterling at 60 days with premium of 9%, being the half year's dividends on the Indian Bank stock to 20th December 1836. So it looks like they're investing in Indian Bank stock in London. The next line, January 7th, 1837, dividend on Upper Canada Bank stock. Sounds like they're investing in bank stock in Canada, in Upper Canada. We also have reference to the 25th of February, a bond from a Messrs. Care and Sautre, S-A-U-R-E. And then on December 20th of 1837, again, you have bank stock, Indian bank stock with a premium of 7%, being 12 months dividends. And then on the bottom of this page, you've got Upper Canada Bank stock dividends. And it continues on the next page. Bills of, I'm not going to read them all, but there's bills of exchange, stocks, dividends, bonds, interest from individuals, personal loans of interest from people, exchange on London for dividends on bank stocks. So, and you'll see that there's a reference to John H. Dunn, the principal trustee of the First Nations. So these are monies that were invested on account with the trustees. And John Dunn is identified as the principal trustee in some of the years. I don't want to belabor the point, but to say that there's no evidence of possible investments in England by Aboriginal people is not fair. In fact, the Bagot Commission talks about the Six Nations specifically because they're the ones that really had the most money in the accounts that could be invested. Now, I think another way to look at the bring forward rate is to draw upon the example of assessment of loss in the Guerin case. Now, I appreciate Guerin was a fiduciary case, but if the court finds its way to accepting our position that an assessment of loss is an appropriate way to proceed and that the court should be looking at equitable considerations, think about what happened in the Guerin case. In that Guerin case, the band had authorized a lease of the land for purposes of golf. They had said to the Crown, go ahead and lease this for the purposes of a golf leasing on terms that a golf company never would have accepted. Now, when the Crown was sued, the measure of loss was not pretending that the golf company would have entered into the golf lease on the terms the band authorized, nor did the court simply accept that there was no loss because the land never would have been leased as a golf company, as a golf business. Instead, the trial judge, and was affirmed by the Supreme Court of Canada, took this thing called a common sense approach and said, eventually, after some time, the band would have eventually leased the land for its highest and best use, which was a residential development. So the same could be said in this case. If investment in the market or in human capital is not seen by this court as equivalent to at least 60-40 market rates, eventually common sense tells us that the enormous amounts of money would have found their way into investment accounts, earning at least 7.2%, if not more, over time, after some short period of time, whether it's Professor Kersner's 10 years or Dr. Dribbin's 20 years. And if you look at the actual dollars involved, there wasn't actually that much money in the early years, in the first 15 years. The money starts coming in the 1870s. Time for them to learn how to invest. I think I have 3 more subjects or so. Relative wealth and needs. Unless there's questions, I'm going to go on. Relative wealth and needs. Canada argues that there were many wrongful acts by the Crown, and perhaps others, that contributed to the wealth disparity over the last 173 years, and argues that the wealth disparity was not solely caused by the failure to pay the augmented annuity. It seems to me that in saying this, Canada is arguing that we are trying to prove causation in respect of the wealth gap, that we are trying to prove that the loss that results from the failure to pay the annuity is equal to the wealth gap. That's not what we're doing at all. The wealth gap was something the Court of Appeal directed us to look at, the relative disparities, as I think a litmus test on where the numbers take you on sharing. If causation was where we were at, if we were saying the loss of opportunity is the wealth gap disparity, our claim would be for 193 billion, not for 126 billion. In any event, I say it does not lie in the mouth of the wrongdoer to ask the court's indulgence on the basis that they committed other wrongful acts that contributed to the wealth gap. And moreover, if Canada or Ontario thought that it was important to establish as fact that there were other actions or other wrongful acts of either the Crown or other people that caused the wealth gap, it behooved them to bring that evidence in a cogent manner, or cogent evidence to prove that. This they did not do. A couple words on future implementation when the court is ready.
A minute, please. Go ahead, thank you.
On future implementation and on September 15th, got a note, transcript, page 86, Canada argued that the judgment is aspirational. Respectfully, judgments are not aspirational. Judgments should be abided by. Secondly, Canada argues it's problematic to use historic data to quantify resource rents because the data was not kept properly, but then argued there's no ability to keep track of RST territory-wide revenues and expenses now, and that we should simply use the process that was used in the past. My point here is that if that is where we're at, if the Crowns are going to refuse to keep track of revenues and expenses within the treaty territory, then it makes ever more sense to simply continue to use the Hutchins model and the percentage of expenses going forward until two things happen. One, the data is kept properly, or two, the parties reach agreement otherwise. Now, the court on this score said, what about a limited term? I think that's a good idea, actually. I don't think the parties should be invited to go back every single year to litigate before the courts what the entitlement is. There needs to be some stability. There needs to be some bridge building. But I would suggest that concrete guideposts that in effect generate a number that needs to be paid should be the goal of the judgment. And my suggestion is that given the forever nature of this treaty, knowing that it took approximately a quarter century for Canada and Ontario to sort out their differences in 1873, and knowing that there has been almost a quarter century for this case to wind its way to this stage, it would not be inappropriate, indeed it would be appropriate, to have a 25-year cooling off period, so to speak, whereby the court can direct that absent agreement of the parties, and let their, give the parties an opportunity to say otherwise, but let the parties be able to negotiate on an even keel. Set the terms, set the guideposts, so that neither Ontario nor Canada has an upper hand in any kind of negotiations, so that the parties can negotiate as equals. How specific should those guideposts be? They should be specific as we've asked for in our relief. And Canada's response to really a request to avoid guideposts or of concrete guideposts was to say, well, but look at Canada, we've shared information about the past. Respectfully, that was shared only after 20 years of litigation and a court order by which they, and a court process by which they were required to share information. Canada then says, well, we've met and experts have hot tubbed. Well, assuring us that in the future litigation, they will act reasonably is something I would be grateful for as a lawyer, but it's of little solace if we have to bring litigation every year. And we have seen that experts hot tubbing when their views of what is required are so far apart is unhelpful. Thirdly, Canada argues, don't judge us by our past conduct. We've changed. But have they really? Their present positions, both crowns in this litigation, respectfully, I say, provides no comfort that really anything has changed. What Canada and Ontario are saying is they're invoking little more than trust us. You can trust this fox. Respectfully, no trust has been earned. Timing of release of decision. Ontario makes the point that on the issue of waiting for the Supreme Court of Canada, we had originally advocated for a wait and see approach, indicating the possibility that perhaps there could be more evidence or more argument, and then in effect that your decision should be reserved until you hear from the Supreme Court of Canada. That was based on what I knew then. I've now listened to the evidence. I've now heard the evidence. I've now, quite candidly, I started at the start of my oral submissions. I've reconsidered my position. I don't think it's a good idea to wait. I am not at all convinced that any new evidence will be required or any need for new evidence, or put it more likely, the need for new evidence is, as I said before, speculative, and it does not warrant holding off. And to the extent that people accuse me of changing my mind on this, I'll accept that. What really struck me before I made the comments at the outset of my opening remarks was, as I said before, not seeing the faces of the people in the community that I used to see. And I don't know who it was who said justice delayed is justice denied, but nothing is truer than in this case. In a moment, oh, sorry, I'll just wait for you to catch up. In a moment of what I would consider to be candor, for which I thank them, Ontario's counsel explained to this court yesterday morning that their vision of the treaty and the obligations flowing from it are the ones espoused by their experts, Smart and Bodway, at paragraph 165 of their report, volume 3. And if you look at Ontario actually set it out in their compendium, volume 3, tab 52. Ontario Council took you to paragraph 165, where Professors Smart and Bodway identify the Robinson Treaty as like a property transaction and not a sharing arrangement. This core characterization is fundamentally at odds with the relational, sharing, wait and see, jointly beneficial treaty relationship that this court in stage one and the Court of Appeal affirmed lies at the heart of the treaty bargain. The Crown's theory, both Ontario and Canada, is at odds with respect, responsibility, renewal, and reciprocity. I do not recall any of Ontario's experts giving any thought to those principles in their considerations. I don't recall Professors Mincer or Ryden giving meaningful weight to those considerations either. Now, given that we have talked about railroads and colonization roads and their import, perhaps I can be forgiven for the analogy that follows. The Crown's approach to this treaty, in this case, in 2023, is not simply a train that has gone off the tracks somewhere down the line. Respectfully, the Crowns have gone off the rails before even leaving the station. The Crown train is a train to nowhere. It would be hard to envision and imagine a treaty and the Crown's responsibility under it that is more at odds and so offends the honor of the Crown and the spirit of reconciliation than the visions put forward by the Crowns in this 2023 case. And with that, I thank the court for its indulgence. I thank my friends for their assistance throughout this case. And unless there are any questions by the court, that would conclude my submissions.
Thank you. No further questions. Thank you, council. Thank you all, council. As I said at our break, it has been a privilege to work with all of you. So thank you for the submissions, the record that you have created. Of course, I will be reserving my decision in this case. Ontario, joined by Canada, has asked that I delay my decision in this case, and I will consider that. And should I decide to delay, I will give you that decision in short order. And otherwise, and I'm thinking long and hard before I say this, but otherwise, my goal is to get you a decision within 6 months. And that does not bring us to Christmas Eve. You'll be happy to hear. So with that, I believe there is an arrangement where the eagle feather that has been in this courtroom throughout the submissions will now be returned to its place in this building, the Aboriginal courtroom, and Elder Donio is here to lead that, and all in the courtroom are invited to follow in a procession of returning the eagle feather. Please join me. Thank you. Okay.
The Superior Court of Justice is now closed.